Hi, and welcome to this video on the Bruton problem. Normally, as we've seen in class, figuring out whether it's okay to join two defendants together for a joint trial is really just a question of applying two rules. Rule 8b of the Federal Rules, which provides the legal standard for when it's appropriate to join two defendants in a single charging instrument, and then also Rule 14, which helps a judge determine when the prejudice that one defendant might suffer is too great and therefore requires some kind of a remedy, including a severance or an order that the two defendants be tried separately. Well, in one scenario, joining two defendants for trial can violate not the rules, but actually the Constitution. It can violate the constitutional rights of one of the two defendants. This presentation focuses on that scenario, which is called a Bruton scenario. And it's called Bruton because that's the name of the landmark 1968 Supreme Court case that first linked up this issue of joinder of two defendants with constitutional law. All Bruton scenarios involve conspiracy, jointly undertaken criminal activity among two or more defendants. Something kind of like this.
Okay, Frank, so listen up. Here's what we're gonna do. I'm going in to grab some money from the cash register. You stay here and make sure nobody comes into the restaurant.
That's a fantastic idea, Jimmy. I will wait right here and make sure nobody comes in.
So you've got Jimmy and Frank outside the McDonald's agreeing to stick the place up, with Jimmy going in and grabbing the cash, and Frank staying outside to act as the guard, basically, to make sure nobody comes in. And you've got a woman standing next to them who might be overhearing their conversations. So there's the crime. What you also have in every Bruton scenario is a post-arrest statement or confession. Something kind of like this.
Thank you for signing the Miranda waiver form. Now please tell me exactly what Jimmy said to you outside the restaurant.
Jimmy told me that he was going to go inside and grab some cash and that I should make sure nobody came in.
Did you say anything to Jimmy?
I told Jimmy I thought that was a good idea.
So that's the second component of a Bruton scenario, a post-arrest statement to the police by one of the co-defendants, implicating himself, Frank in this case, and also implicating his co-defendant, Jimmy, in this case. So now let's think about what might happen at trial if the state wanted to use or introduce evidence of what it is these people said. Now notice there's two different sets of things that were said. One is the set of comments that the two defendants made to each other outside of the McDonald's at the time that they were actually committing the crime. The other statement is the statement that Frank gave to the police after he was arrested. Let's think first about the first of those scenarios. How would things play out at trial if the state wanted to offer evidence of what the two guys said to each other outside of the McDonald's? The prosecutor would probably try to get that conversation in through testimony from the woman who was standing next to them and probably overheard what it is they were saying outside the McDonald's. Probably would go something like this.
Please tell the ladies and gentlemen of the jury what you heard outside the restaurant.
The tall guy told the short guy that he was going to go inside and grab some cash.
I object to this testimony. It is an out-of-court declaration that the prosecutor is offering for its truth.
Okay, so you got that? the woman is testifying about what she heard Jimmy say to Frank. Jimmy's lawyer objects on the basis that it's hearsay, an out-of-court statement being offered for its truth. But under the rules of evidence, as to Jimmy, that argument is wrong. The state is offering Jimmy's own statement, and it's the statement of an opposing party. So under the rules of evidence, it's not hearsay.
I have a different hearsay objection. The witness is talking about what Jimmy said. Those words can't come in as to my client Frank. They are not Frank's words. They're hearsay.
So when the state offers Jimmy's words, or for that matter Frank's words, against Jimmy and Frank, they come in one case because they're the statement of an opposing party, and in the other case because of the co-conspirator exception to the hearsay rule. So this is how it plays out.
Did he say anything else?
He told the short guy to stay outside and make sure nobody came into the restaurant, and then the short guy told the tall guy that he thought that was a great idea.
So now we get to the interesting part, the scenario that led to the Supreme Court's ruling in the Bruton case. Suppose that what the prosecutor wants to do is to offer not the eyewitness testimony about what she heard them saying during the conspiracy, but instead the statement that Frank gave to the police after he was arrested. That segment of the trial might go something like this.
Your Honor, the state would like to call Officer Carlton Johnson as its next witness. And after Frank signed the Miranda waiver form, what happened next?
Well, as I recall, Frank made a statement. He said Jimmy told him he was going into the restaurant to grab some cash. And he said Jimmy had told him to make sure nobody came in.
Objection. My client Frank's statement to Officer Johnson is being offered for its truth, and is therefore inadmissible against my client, as hearsay.
Well, I have a separate objection, Your Honor. Even if Frank's statement is admissible against Frank, it is hearsay. As to my client Jimmy, it is not Jimmy's statement.
But Your Honor, the state is not offering it against Jimmy. We're offering it only against Frank. The jury can be instructed to consider it only against Frank, and not Jimmy.
So there you have it, the Bruton problem. The state introduces Frank's confession. In the confession, Frank implicates himself, and he implicates Jimmy. It's admissible against Frank because it's his own statement. It's the statement of an opposing party. But it's not admissible against Jimmy. It's not Jimmy's statement, and the co-conspirator exception is no longer available, because when Frank gave his confession to Officer Johnston, the conspiracy was already over, and the statement was no longer in furtherance of the conspiracy. That's why the prosecutor tries to salvage the situation by floating the idea of a limiting instruction. Tell the jury that they should consider Frank's confession only against Frank and not consider it against Jimmy. The Supreme Court's insight in the Bruton case is that while juries usually follow instructions like this, when it comes to a confession, they probably can't, because confessions are just devastating evidence. It's just too tempting to believe what Frank is saying about Jimmy when Frank is confessing to being involved with Jimmy in the crime. And that's where the confrontation clause comes in. If the reality is that the jury is going to consider Frank's confession against Jimmy, no matter what the court tells them to do, if the state is in effect making Frank a witness against Jimmy through that statement, through the confession, then Jimmy ought to have the chance to confront the witnesses against him, to confront Frank. But Jimmy can't do that because Frank has a privilege against self-incrimination, and he's allowed not to take the stand. So Jimmy can't call Frank as a witness. Jimmy is stuck. Bruton says that in a situation like this, to try Jimmy together with Frank is to violate Jimmy's right to confront the witnesses against him. So where does that leave us? Does that mean that the only way to protect Jimmy's confrontation clause rights is to sever their trials and give Jimmy a trial at which the jury doesn't hear Frank's confession? Well, it's not quite that simple. There are a couple of options, actually, to solve this problem, and we'll talk about those in class.